Hello everyone, this is Naresh IAS Academy YouTube channel and today I will explain the entire Indian Constitution through the articles. You know, Indian Constitution is lengthiest constitution in the world, while the American Constitution is ancient and the smallest constitution. The Constitution of India was framed by a Constituent Assembly organized under the Cabinet Mission 1946, and presently the Indian Constitution has 22 parts and the 4 supplement subpart. Initially there were 395 articles in the original Constitution and 8 schedule, but now the number of articles has been increased more than 400 and schedules are 12. So first of all I want to say that if you are from the Hindi medium student, I have already discussed the articles for the Hindi medium students and this is exclusively for the English medium students, and you may contact for the IAS exam preparation. I have already discussed the General Studies paper 1 and General Studies paper 2 for the IAS mains exam. Definitely you may take L for how to answer writing and how can be obtain the maximum marks, and the further I have discussed a specific information through the videos. So first of all, this is the part 1 of the Indian Constitution. The part is explained by the article 1 to 4 and the name of the part is the Union and its territory. The article 1 states that name and the territory of the Union, India, that is Bharat. This is the official name of our country, India, and here the Bharat is the translation. You know, the article 1 also include the numbering of the Indian states. Presently the India has 28 states and the 8 union territories, and this is a sequence order of the state under the article. Article 2 says that admission and establishment of the new state. You know, Indian Constitution provide a complete procedure for the inclusion, establishment and creation of the new state. At the time of the implementation of Constitution on the 26th January 1950, there were 14 states, and from the 14 states to 28 states we have completed a long journey, and this shows the Indian Constitution is flexible than the rigid. So then second article says that Indian government can decide criteria for the admission and establishment of the new state, and the article 3 says formation of new states and alteration of areas, boundaries and name of existing states. And according to this article, Indian Parliament is the absolute authority regarding this, and any new states can be created after the prior sanction of Indian President, and then a resolution is passed by the both house of Indian Parliament, the Lok Sabha and Rajya Sabha, and through this process the name of the any states and the boundaries of any states also can be altered. And the article 4 says laws made under article 2nd and 3rd should be prevail for a long time whenever the Indian Parliament do not repeal them. So this is the part 1 and completely explained by the article 1 to 4, and it is not possible for me to discuss the about 395 articles thoroughly, but I will try to explain the important one part of the articles, and somewhere I will suggest you how you should understand and learn these articles. Okay, The part second of constitution is the citizenship, and the general information you must have, like the India have adopted the provisions of single citizenship mainly from the UK constitution. However, UK do not have the written constitution rather than the convention. Indian constitution provided the single citizenship, and article 5 to 11 explain the citizenship provisions. For example, article 5 says citizenship at the commencement of the constitution. It means when the constitution was implemented on 26 January 1950, at the time of commencement, all the peoples of India provided the citizenship under the various categories like the article 6, 7, 8. Then article 6 says right of citizenship of a certain person who has migrated to India from Pakistan. So after the partition of India, the article was very helpful for those person migrated to India from Pakistan, and they were included as the citizens of India. And according to article 7, rights of citizenship of certain migrants to Pakistan, and those peoples migrated from India to Pakistan, then they were excluded from the citizenship. And article 8, rights of citizenship of certain person of Indian origin residing outside India. It means that time those person were residing in the outside India or the abroad countries, and under the specific circumstances they were adopted as a citizen of India. Okay, so article 6, 7, 8 are the implementation of article 5. Article 9, 10 and 11. Article 9 says people voluntarily acquiring citizenship of a foreign state not to be citizens. It means Indian constitution only grants the single citizenship. At a time a person may be a citizen of India, not the citizen of any other country at a time. You know, if any person have taken or adopted the citizenship of any foreign country, so immediately the Indian citizenship lapses there. So the article 10 says continuance of rights of citizenship. It means all the citizens of India may have their citizenship rights for a long time whenever the Indian Parliament do not try to deprived of those persons if they have made something wrong against the country or if they have violated the rules and instruction of the Citizenship Act. Article 11 says Parliament to regulate the right of citizenship by law. Yes, Indian Parliament is the absolute authority, so Parliament as per the time can make laws, and Parliament have done so. Parliament can restrict, can limit, can enlarge the rights of the Indian citizens. Okay, this is the second part. And now the third part. Part third of the Constitution is the fundamental rights, and this part is extending from Article 12 to 35. Article 12 explains the definition of state. You must know here, the term state only has been mentioned in this article, not defined. Further, the term state have been defined by the Supreme Court as the central government requested, because Supreme Court is custodian of the Constitution and the final interpreter of the Constitution. And Article 13 says the judicial review laws inconsistent with or in derogation of the fundamental rights. And this article has been explained under Article 13 clause 1, 2 and 3. And the term law have been defined, and what are the laws, and laws if they are not accordingly with the Indian Constitution, then Supreme Court can declare invalid. From the Article 14 to Article 32, this is the classification of fundamental rights. You know, first article is the right to equality, and it has been explained from Article 14 to 18. Initially there were 7 fundamental rights in Indian Constitution, but now these are 6 because one rights, the right to property, has been shifted from the fundamental right to legal or statutory right, and it has been placed in part 12 of Indian Constitution in the article 300A, right? And the fundamental rights have been taken from the American Constitution. Article 14 says equality before law and equal protection of law. This include equality before law means all the citizen of India or even the foreign person should be treated equally by the Indian court, and Indian court will not discriminate among the person or citizens on the different ground, caste, race, religions, etc. And the second clause of this article, equal protection of laws, has been taken from the America, and it means the same provisions and the one kind of law is applicable to the same circumstances of the person, and law may be discriminated according to the circumstances. Article 15 says prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. It means all the public places are freely open to all the citizens, and states or even private person cannot discriminate on the different grounds. And under this article in India, reservation to SC, ST and OBC in the education has been provided, and also the National Commission of Women also established under this article. Article 16 says equality of opportunity in matters of public employment. It means the categories of SC, ST and OBC have been given reservation under the government jobs under this article. Article 17, abolition of untouchability. It means now we cannot make any kinds of statements or cannot calling for any person with their caste or any inferior terms, because now it has been declared a offense, and for this Indian Parliament have made the Civil Rights Protection Act 1976 Article 18 abolition of titles. Titles were the specific privileges granted by the British government to the Indians, like the Rai Bahadur Sir knighthood, and basically these titles were creating the discrimination among the Indian persons, and that's why under this article these have been abolished. But the different type of awards like the Bharat Ratna Award, Rajiv Gandhi Khel Ratna, Gyan Peeth Award, the Padam Awards are allowed because these are not the titles, simply the awards. Second fundamental rights is right to freedom or the right to liberty. It has been explained from the article 19 to 22. Article 19 states that protection of certain rights regarding freedom of speech, etc. And this article includes the multiple rights of liberties like right to speech and expression, and right to media or press is also a part of right to speech and expression. We have the right to speech and expression under article 19 clause 1, and right to freedom throughout the country, a right to settle in any part of the country, right to carry any kinds of occupation, right to assemble, and right to organize the political parties and the other institutions. Different type of liberty the article 19 granted to the Indian citizens. Article 20 provided that protection in respect to conviction of offences. It means any person who have made something wrong or committed offence against the Indian person, society and country, and a person cannot be punished for twice for a same kind of offences or crime, and a person never be compel for the witnessing against himself. And this article also provided that the narco test, brain mapping and polygraph may be applied in the rarest cases after the permission of Supreme Court. These are the sub-particles of the Article 20. Article 21 provided the protection of life and personal liberty. Life and personal liberty or the physical liberty. And Supreme Court have broadly explained this through the different historical cases and right to marriage and the right to privacy, right to education, and so many different rights have been Supreme Court included to maintain a right to life. And one interesting point is right to death, which is called the right to euthanasia. But under this article, only the passive euthanasia have been granted, not active. Right to education under Article 21 have been added as a fundamental right, and Article 22 provided that protection against arrest and detention in certain cases. It means general law applicable when any person committed any offense or crime, he may be arrested, and during the arresting period there may be some provisions of safeguard for that person. But a preventive detention means what? Before committing any crime, you may be detained and you may be prevented from committing any crimes, because according to which it emphasizes to avoid any kinds of loss or damage to the country by the such persons. And Government of India or Indian Parliament have made different type of laws under this. For example, the TADA Act, TADA Act 1987, POTA Act 2002, Coffee Posa Act, MISA Act 1980, MISA, the MISA Act, Internal Security Act. The maintaining the Internal Security Act 1980 is prevailing to the country from such kinds of anti-nation activities. The third fundamental right is right against exploitation, and this fundamental rights is explained by Article 23 and 24. Article 23 says prohibition of traffic in human beings and forced labor, and broadly this article includes the prohibition of beggar system, bondage labor, human trafficking and the prostitution, because this is against our right to life. And Article 24 prohibit the employment of children below the age of 14 years in factories or any dangerous work, because this may be one cause of our exploitation. Next fundamental right is right to freedom of religion, and this right provided the 4 kinds of liberty to all the religious community in India, and through which we can ensure the secularism in India. Article 25, freedom of conscience and free profession, practice and propagation of religion. And under which article the term Hindu have been defined by the Supreme Court, include the Sikhs and Buddhism. And right to convergence, you may change your religion anytime, and it has been under this article. Article 16, freedom to manage religious affairs. Article 27, freedom as to payment of taxes for promotion of any particular religion. Article 28, freedom as to attendance at religious instruction or religious worship in certain education institutions. It means if any educational institutions is funded by central or state government, then the institutions cannot compel the person for the religious education, because it is not absolutely the religious organization, because government is one part of this. The next fundamental right is cultural and educational rights. Article 29, Article 30. And this right is also called the rights of minority class in India. And except the Hindus, all the community in India are the minorities. The minority means what? Community having less than 50% of population. Article 29 provided for the minorities to protect their language, script and cultures. And Article 30 provided to the minority to establish and administer educational institutions like the Aligarh Muslim University, Saint Soldier Academy. These are the rights granted to the minority institutions, and they can enjoy and they can maintain their culture, their education, religious affairs. So the Indian Constitution provides the complete liberty or respect to the minorities. So there is no matter of fear and threat. Article 31 and Article 19 include the right to property. Now it has been repealed from this part. Right to constitutional remedies, this was the last fundamental rights, Article 32. Dr. B.R. Ambedkar called these fundamental rights as heart and soul of the Indian Constitution, because whenever any person or government agency tried to violate our fundamental rights, we can seek the remedy or relief from Supreme Court, and Supreme Court immediately issue the 5 kinds of writ: the mandamus writ, quo warranto writ, prohibition writ, certiorari writ, and the habeas corpus writ for the protection or restoring the fundamental rights. Article 33, power of Parliament to modify the rights conferred by this part in their application to force. It means any person who is serving under the army, police, paramilitary forces, then their fundamental rights may be limited by the agencies. And Article 34 says, if any part of India is under the martial law and the action of the army in this territory cannot be questioned in any court of the India, whatever they done. And Article 35 says, legislation to give effect to the provision of this part. It means whatever laws has been made by the Parliament, central government to enforce the fundamental rights, they may be sustained forever whenever the Indian Parliament do not repeal them. Okay, this is the part 3rd. Absolutely, you should try to learn and understand in this way. The next part 4 is directive principles of state policy. This is the part 4, name of the part 4. Okay, and these elements we have taken from the Ireland Constitution. Ireland is a country of Europe now, and this part is extended from Article 36 to 51. Article 36 again definition of state, but the Constitution does not define the state. It was further defined by the Supreme Court. Article 37 says, application of the principles contained in this part. It means these are fundamentals of the state policy. State means the central government and state government and the other multi-member bodies or law enforcing agencies. So Article 37 direct the central and state government to consider these elements while making any law. Article 38 ensure state to secure a social order for the promoting of welfare of the people, and under this article state have been directed to ensure the social justice and how can we convert India as a welfare state. So state should take the different type of the efforts in this direction. Article 39 states that certain principles of policy to be followed by the states. For example, the equal pay for the men and women for the equal work. The equal pay for equal work to the men and women. This is a sub clause of the Article 39, and some of the other clause are also, you must learn them. Article 39A, this is added by the 42nd Amendment in 1976 by the Prime Minister Indira Gandhi's government, equal justice and free legal aid to the weaker section of society. Article 40, the organization of village panchayat. This article directs the state government to organize the village panchayat, and you know, throughout the country, village panchayat municipalities has been established. Article 41 provided that right to work, to education, to public assistance in certain cases. In case of the unemployment, states should provide right to job, right to work. In case of the illiteracy, the states should provide the education. In case of the poverty, states should provide the public assistance and the health facilities, and this is also applicable. Article 42, provision for just and human condition at the working place and maternity leave, right? This is applicable. Article 43, living wage as it is for the workers and establishment of cottage industries. States have directed to establish cottage industries because these are the small scale industries provided job for the entire family. And Article 43A, this was added in 1976 by 42nd Amendment by the Indira Gandhi government. Participation of workers in the management of industries. Now, the workers are included as the shareholders. Article 44 directs the state to implement uniform civil code for the all citizens. In the criminal cases, we have already have the uniform criminal justice, but this is the civil code. You know, in India, all the religious communities have the different type of civil codes. Hindus have their personal laws, the Manusmritis and Vedas. Muslims have the Sharia law and their personal law, Jain Buddhism, and mostly this is against the fundamental rights of women, because these personal laws definitely for some extent derogate the fundamental rights of women, and this article has not been implemented yet. Article 45, provision for early childhood care and education to children below the age of 6 years. Initially, there was provision of education for the age of 6 to 14 years, and through the Right to Education Act, it has been provided, right? And now, the care of the children below the age of 6 years has been added later on. Article 46 provided facilities to the scheduled castes, scheduled tribes and other weaker section. Okay, it is implemented. Article 47, duty of state to raise the level of nutrition and standards of living and the improve health. Okay, it is also applicable in India. Next, Article 48, organization of agriculture and animal husbandry. Agriculture policy and the policy for animal husbandry has been made by the central state government, so this is not a matter. Article 48A added by the Indira Gandhi government in 1976 through the 42nd Amendment, and this provided protection and improvement of environment and safeguarding of the forest and wildlife. Article 49 provided protection of monuments and places and objects of national importance. It means the cultural heritage. Two kinds of cultural heritage, natural heritage and the cultural heritage. All the national monuments have been protected under this article. Article 50, separation of judiciary from executive. Okay, executive branch is separating and judiciary under the Supreme Court, High Court and lower court are working separate, so there is no matter of conflicting to each other. Article 51, promotion of international peace, stability and security. From this article, India have derived its foreign policy, right? Article 51A, the 11 fundamental duties. You know, in the original constitution, there were no fundamental duties. These were added by the Indira Gandhi government in 1976 by the 42nd Amendment, and through the Amendment 42nd, Part 4A was created, Article 51A was added, and there were 10 fundamental duties. And these duties were added in Indian Constitution on the recommendation of Swan Singh Committee. Swan Singh was a Congress leader that time, an important leader. who suggested, and fundamental duties we have taken from that time of USSR, Soviet Sangh, now the Russian constitution. Okay. And one fundamental duty, right to education of the children, added later on. So now these are 11. Part 5, the lengthiest part of constitution. First of all, it includes the provisions about the Indian president. Article 52 provided that there shall be a president of India, right? Article 53 says executive power of the union. It means president is the head of the nation. So the executive power will be in the hand of president. It means all the executive function actually performed by the prime minister and his government done by the name of president, and later on prime minister is bound to convey or discuss all the matter with the president. Article 54 says election of president, and 55 manner of election of president. Election of president means what? President is the first citizen of India, right? And he is the elected person in India, and he is the symbol of Indian republican system. And Article 54 includes who can vote to president. So there is an electoral college including only elected member of Lok Sabha and Rajya Sabha, and only elected member of state Vidhan Sabha assemblies or the Vidhan Sabha of union territories. The Indian peoples cannot vote, nominated member cannot vote, and vice president cannot vote to the president, because vice president is not a elected member or any kinds of member of the Rajya Sabha, the upper house. And 55 article says the manner of election of president. This is a manner. What is the process? First of all, we have to calculate the vote value of each MLAs and the total MLAs of the country, and the vote value of member of parliament. Then the minimum quota more than 50%. One. Article 56, term of office of president. President का term 5 years, and before the 5 years the term may be ended by his resignation, by the accidental death, by the removals, and he may be elected for any number of terms. So there is no bar. Article 57, eligibility for re-election, yeah, possible है. Article 58, qualification for election as president. Different type of qualification, like he must be a citizen of India, and he must have completed the age of 35 years, and maximum age may be whatever, there is no bar. Article 59, condition of president's office. Any person who is contesting the election of president, there are some conditions. He must not be a member of parliament or any state assemblies, and must not have under the public services or these kinds of. And Article 60, oath process of president. You know, the oath process of president is not under the 3rd schedule, and Chief Justice of India subscribe oath to him. Article 61, procedure for impeachment of president. President is removed from his office by the impeachment process. And Article 62, not very important. Article 63, the Vice President of India. Article 63 says that there shall be a Vice President of India, right? And Vice President is the elected member. Article 66 says Vice President is elected by both the House of Parliament. You know, this is the difference between the election of President, Vice President. All the elected and nominated member of Lok Sabha and Rajya Sabha vote to Vice President, but nominated member of Lok Sabha, Rajya Sabha cannot vote to President, and the member of Vidhan Sabha cannot vote to Vice President, but can vote to the President. Article 67, term of office of Vice President, 5 years, and he may be re-elected for any number of time. There is no bar. And you know, Article 69, oath or affirmation of Vice President. Indian President subscribe oath to Vice President, right? And Vice President has no functioning as a vice president, either he may act as a president in case of accidental death or absence, and he is the ex officio chairman of Rajya Sabha, right? Union Council of Minister, Article 74, Council of Minister to aid and advise President, according to which the Indian President is a nominal head, but the actual head, de facto head, is the Prime Minister. So the Indian President is bound to act on the advice of Union Council of Minister, and this council is headed by the Prime Minister. The President only can return the advice once to the Council of Minister. Article 75 makes provision about the ministers, under which first the Prime Minister is appointed by the Indian President. Other ministers along with the Prime Minister are appointed by the President on the advice of Prime Minister. Any person may be Prime Minister or Minister without being a member of Parliament for the 6 months. And further added the size of Council of Ministers. And now in India maybe the ministers 15% of the total strength of Lok Sabha in the present time, and it cannot be exceed. The different type of provisions have been made under this, and the collective responsibility. Prime Minister and his Council of Ministers is collectively responsible to the Indian Parliament. 76. Attorney General of India, the first law officer of India. First law officer of India, he is appointed by the Indian President on the advice of Prime Minister and his Council of Ministers, and he is generally appointed for the 5 years, but under the pleasure of President, and he has status equal to the judges of Supreme Court, and he is the only authority in India without being a member of Parliament can sit, can join, participate in the proceeding of Parliament. Okay. Conduct of government business, you should try to understand Article 77. Conduct of business of Government of India means what? All the business or functions of Union government shall be done on the name of President, and President may prescribe the format of doing the business. And Article 78 bound the Indian Prime Minister to furnish the information to the President regularly what action his government has been taken in India or abroad. And next, the Indian Parliament. Article 79 makes provision about the Indian Parliament, and it means the Parliament is a bicameral, has the two houses, Lok Sabha and Rajya Sabha. Lok Sabha is the lower house, Rajya Sabha the upper house, and Parliament has the 3 organs, President, Lok Sabha and Rajya Sabha. Article 80, composition of Council of State. The Council of State, the upper house, permanent house, never dissolve. Article 81, composition of House of People. It means Lok Sabha. The first house, lower house or House of the People. 82, readjustment after each census. After the 10 years, census is made in India and the constituencies are readjusted. Duration of the House of the Parliament, Lok Sabha generally sit for the 5 years, and Council of State, the permanent house, never dissolve. However, the general term is the 6 year. Qualification for member of the Parliament, Lok Sabha members ka qualification are different from the Rajya Sabha members. You should to try to understand. Article 85, the session of Parliament, prorogation and dissolution. Indian President summons the session of Parliament, 3 session, budget session, summer session, winter session, prorogation made by the Indian President, and President dissolve the Lok Sabha after every 5 years, right? And these are the all important articles. You should try to yourself write the Article 89. Look at the Article 89. The chairman and deputy chairman of the Council of State. Rajya Sabha is headed by the 2 presiding officers, chairman and the deputy chairman. chairman is always the vice president of India and he the ex officio chairman. And the different provision about the chairman and the deputy chairman, then their powers, and article 93, the speaker and deputy speaker of the House of the People. Lok Sabha has the speaker, the presiding officer and the deputy speaker. Okay, same provisions, article 94, 95 their powers, 96 salary allowances of chairman, deputy chairman, speaker and deputy speaker. Secretariat of Parliament, Lok Sabha has its own secretariat, Rajya Sabha has its own secretariat. Oath or affirmation of by the members. Lok Sabha members are subscribed oath before the pro tem speaker, and in Rajya Sabha chairman provided oath. And voting provision article 100 and disqualification of the member. These are the different articles, like the vacation of seats, in which the provisions has been made. Any member absent without informing the presiding officer for 2 months or 60 days, he may be disqualified and his place may be vacant. Disqualification of member, different grounds has been made. Decision on question as to disqualification of member. There are two kinds of decisions. In case of the Election Commission of India recommend to the President, and on the matter of defection, the House itself authority. Okay. And then article 105, powers, privilege, it's of the House of Parliament, salary allowance of members, provisions, including the passing of bills. Okay. Article 108, very important, joint sitting of both houses in certain cases. So then, if there is any disagreement between Lok Sabha and Rajya Sabha, generally over the ordinary bills, there may be a joint sitting under article 108. President called the joint sitting and Lok Sabha speaker presiding the joint sittings. Article 109, special procedure in respect of money bill. The procedure have been defined. Procedure means what? The money bill only can be introduced in Lok Sabha first. First, you have to obtain the prior sanction or permission of President. Lok Sabha speaker certified that is money bill or not. Rajya Sabha have only the power to detain 14 days. Article 110, definition of the money bill. There are the 6 points define the money bill. Article 111, assent to bills. Assent to bills means what? President can exercise his veto power over the bills. Procedure in financial matters, annual financial statement, article 112, this is also called the budget. Okay. Article 113, procedure in parliament with respect to estimates. Estimate. Appropriation bill, article 114, appropriation bill means a bill which is passed by both houses after the budget, and when the bill is passed, the central government is entitled to withdraw money from the consolidated fund of India. Article 115, supplementary grant, additional grants. Okay, votes on account, very important. Article 116, votes of credit, exceptional grants. Financial bill, the difference between the money bill and the financial bill I have to explain in the different videos, so you should take help from there. Rules of procedure not important, and this is not upon legislative power of the president, right? Article 123, powers of president to promulgate ordinance. You know, ordinance is a one kind of law issued by the president on the advice of union government. The union judiciary, article 124, establishment and constitution of Supreme Court. Then constitution of the Supreme Court, article 124, and it makes provision the appointment of the judges. The Supreme Court has one chief justice and other judges, all are appointed by the Indian president, and their term is for the 5 years or age of the 65, and there are the different type of qualification, and how the judges be dismissed from their offices. And there is a parliamentary process. Article 125 makes provision about the salaries, etc. of the judges. 126 appointment of acting chief justice. Acting chief justice when the chief justice of India is not available. Appointment of ad hoc judges to complete the quorum. The ad hoc judges are appointed and it has been taken from the French constitution. Attendance of retired judges at sittings of the Supreme Court. Yes. 129 Supreme Court to be a court of record. All the decision, court of record, all the decisions of Supreme Court are preserved as a court of record for the future reference cases. For the future as a reference cases. Seat of Supreme Court, principal seat in Delhi and it may be in other cities of India. Original jurisdiction of the Supreme Court under Article 131. Original jurisdiction means what? This is two types, absolute or the parallel. Some cases only can be brought before the Supreme Court, not any court of India, and matters of the violation of fundamental rights also under this article. Article 132 appellate jurisdiction of Supreme Court, appeals from the High Court in certain cases. 33 appellate jurisdiction, appeals from high courts in the civilian matters. And article 134 appeal from high court to the criminal matters. Okay, jurisdiction 135. 136 SLP, special leave to appeal by the Supreme Court. Article 137 very important, review of jurisdiction or review of judgment. Supreme Court has power to review their earlier decisions and Supreme Court can change its earlier decision. Okay, these are the not very important, but you must try to listen. Article 143 very important, power of President to consult Supreme Court. The President of India can consult Supreme Court on the various issues under this article. Next is the Comptroller and Auditor General of India. Article 148 CAG. CAG is the head of the Indian Accounts and Audit Department, appointed by the President for 6 years or at the age of 65. He is the only authority, can be dismissed as the judge of Supreme Court are dismissed. Power and functions of CAG. Article 149, Article 150, format of accounts of the Union and States, audit report. The CAG submit to the President in case of Union government and to the Governor in case of the states. Okay, these are the provisions of CAG. Part 6 from Article 152, definition of states. Simply the term states have been mentioned. First of all, Governor. Article 153, Governor of states. A person may be a governor of one state or more than one state. So by the 7th Amendment Act 1956, a person may be a governor of more than one state. And the governor of Punjab is always the administrator of Chandigarh too. Executive power of state shall be in the hand of governor. Like the president, he is the executive head of the state. Appointment of governor, he is appointed by the president under Article 155. Article 156, term of office of governor for the 5 years, and a person may be for any number of time as a governor. 157, qualification for appointment as governor. Okay. 158, condition of governor's office. 159, oath affirmation. The governor takes oath before the Chief Justice of States High Court. 160 article, discharge of function of the governor in certain contingencies. Okay. 161, power of governors to grant, pardon, etc. This power is compared with the president's power. Presidents have the same power under Article 72, but this is the difference. President can pardon and amnesty to those person has been granted the capital punishment or the death sentence, but governor cannot pardon the death sentence but can commute, can reduce the quantum. Okay, Next, State Council of Minister, Article 163. The Council of Minister to aid and advise to Governor, same. The Governor is bound to act on the advice of Council of Minister, headed by the Chief Minister, and there are the other ministers along him. Article 164 makes provision about the Chief Minister and other minister. Governor appoints the Chief Minister and other ministers are appointed by Governor on the advice of Chief Minister. Same as we have discussed in case of the Union government. Any person may be Chief Minister and the Minister for 6 months without being a member of Assembly or Upper House. Collective responsibility also has been declared. Size of Council of Minister, strength of Minister also has been fixed. Right? Article 165, very important, Advocate General of State. As we have discussed the Attorney General of India, this is Advocate General of States, the first law officer of the states appointed by the Governor. Article 166, 167, Conduct of Government of Business. 166, all the business of states shall be done by the name of Governor through the state government, and this is the duty of Chief Minister to convey or furnish the information to the Governor regularly. Next, the State Legislature. Article 168, Constitution of Legislature in States. There shall be a state legislature, may be unicameral, bicameral, right? Article 169 provided that creation of legislature council in state. Any state can create and request for abolition of the upper house legislative council in a state. Only 6 states in India have the upper house. Uttar Pradesh, Bihar, Karnataka, Maharashtra, Andhra and Telangana. Article 170 makes provision about the Legislative Assembly, the lower house, first house of the state legislature. 171, composition of state legislative. Okay. So the second house, the upper house, and this is absolutely same as we have discussed. The Rajya Sabha permanent house never dissolved, while the Legislative Assembly dissolved by the Governor after every 5 years. Then I suggest you should compare these articles with as we have discussed, the Parliament, same provisions. Then Speaker, Deputy Speaker in Vidhan Sabha, Chairman, Vice Chairman in the Legislative Council of Vidhan Parishad, same provision, nothing is new to explain this, okay. Same the disqualification of members of the Vidhan Sabha and Vidhan Parishad, vacation of seat, disqualification of members as we have discussed in the Parliament. Nothing is important. Same the article, the 190 provision as to introduction and passing of bills, money bill, ordinary bills, financial bills. Okay. Money bills, article 198, special provision in respect of money bills as we have discussed. Definition of money bill, same. Assent to bills, the Governor has power to assent to bill or to withhold the bills, and bill reserved for the consideration. Governor may reserve any bill for the consideration of President if the bill is beyond his power. Procedure in financial matters, same. Article 202, the financial statement of the state government, and this is the budget of state government. Nothing is new, okay. Article 213, the ordinance power of the Governor. This is similar to the ordinance power of President in Article 123. High Courts, Article 214, High Courts for the states. Now India has the 24 High Courts, okay. And High Courts to be courts of record, same. Constitution of High Court, Article 216. It means what? Article 16 says, 216 says, there shall be one Chief Justice and other judges, all are appointed by the Indian President, and President subscribe vote to them. A different type of term and condition have been defined in the Indian Constitution. Appointment condition, office of Judge of High Court, okay. application of certain provision relating to Supreme Court to High Court, oath affirmation of judges of High Courts, restriction on practice after being a permanent judge, salaries, allowances, transfer of judge from one High Court to another High Court, president transfer any judge of High Court to another High Court, appointment of acting Chief Justice in case of the existing Chief Justice if he is absent, appointment of additional judges, acting judges, jurisdiction of High Courts. Article 226 important, power of High Court to issue certain writs. Article 32 Supreme Court issue the 5 kinds of writs, and here the High Courts issue the writs. Subordinate courts, appointment of district judges, Article 233. The district judges are appointed by the state governor, and he also transfers, dismiss them after the consultation of Chief Justice of State High Court. The Union Territories, admin of Union Territories. Union Territories are administered by the Union or central government, okay. And Article 239A added later on, creation of local legislature or council of ministers. In Union Territories, Parliament have created or may create legislature or council of ministers, and presently the Pondicherry and Delhi has a legislature or council of ministers. 239AA special provision with respect to Delhi. Delhi has been declared the NCR, National Capital Region. 239AB provision in case of failure of constitutional machinery. Article 240 power of president to make regulation for certain union territories, okay. High courts for union territory. Only the Delhi has separate high courts. Part 9 the Blaze Panchayat. Article 243 definition of the Panchayat. The term Panchayat includes Gram Panchayat at the lowest level. Above the Gram Panchayat, this is the intermediate level, the Panchayat Samiti, and above the Panchayat Samiti is the Jila Parishad, okay. And Gram Sabha, Article 243A, Constitution of Panchayat, Gram Sabha, Sabha of the villagers having the minimum age of 18 years or above the 18 years. This is the Gram Sabha, and all the member of Gram Sabha appoints one Sarpanch or the other Ward Panch, okay. These are the different provisions of the Blaze Panchayat. Duration of Panchayat, disqualification of members, and not very important. Part 9 Municipalities definition. Municipalities also at the tried layers. At the lowest level, municipalities. Of the municipality, this is the city council, Nagar Parishad. Above the city council, Nagar Parishad, this is the municipal corporation, okay. And part 9B cooperative societies added later on 2011 by the 97 amendment. What are the cooperative societies? Different provisions about the cooperative societies. Part 10 important schedule and tribal areas, part 10 of the Constitution. Article 244 and 244A. Article 244 makes provision about the administration of scheduled areas and tribal areas in the 10 states. And Article 244 makes provision about the admin of the scheduled or tribal areas in Assam, Tripura, Meghalaya and Mizoram, okay. When President have right to create any area, the scheduled area, and there is a tribal advisory council, and in these areas the local peoples have given the more powers. Relations between the union and the states. First, the executive or administrative relationship, union government and state government. Article 245 extend laws made by parliament and by the legislature of state. सब्जेक्ट मैटर ऑफ लॉज मेड बाय पार्लियामेंट एंड बाय द लेजिस्लेचर ऑफ द स्टेट. फर्स्ट कह रहा है एक्सटेंट ऑफ लॉज मीन्स पार्लियामेंट कैन मेक लॉ थ्रू आउट द कंट्री एंड लेजिस्लेचर of state can make law over a states. Subject matter has been defined under the union list, state list and the concurrent list. फिर then GST laws के बारे में लिखा गया है. Article 248 very important, residuary powers of legislation has been given to the Lok Sabha. 249 article provided special power to the Rajya Sabha to make law over the state list. Any subject in the state list, Rajya Sabha can make law if the subject is national importance. Article 250, power of parliament to legislate with respect to any matters in the state list. Okay. 251, 252, 253, very important. Legislation for giving effect to international agreement. If India have made any agreement, treaty with the foreign country, then Parliament can make law for this, for the implementation of this. 254, 255, administrative relations. 256, obligation of states and the unions. Control of the union over state in certain cases. It means central government can instruct, direct the state government to protect the nation properties, transport, communication. 257A, assistance to state by deployment of armed forces, other forces by the union. 258, power of the union to confer powers, which is on a state in certain cases. State government can be granted power by the union government. 258, this is reversal provision of 258. 260, 261, public acts, record, judicial proceeding. 262, important, adjudication of disputes relating to waters of interstate rivers or river valleys. 263, provision with respect to interstate council, right? Part 12, the financial relationships. This is in very detail. I will explain only the some of them. This is the article 270, taxes levied and distribution between the union states. Okay, then all the taxes are divided between state and union government under this article. And next, the article 275, grants from the union to certain. Different types of grants in aid are provided by the union government to the states. Important articles. And articles 279, calculation of net proceeds. Net proceed means what? The GDP after minus the losses or expenses of the government. Article 280, the finance commission. There shall be a finance commission, union finance commission. It has the one chairman or the 4 members. All are appointed by the Indian president for the 5 years. Makes provision for the allocation of finance revenues between central and state. Recommendation of finance commission to the Indian president. Now this is not important for extent. Right. Article 293, borrowings power. 292, the borrowings by the government of India. Government of India can borrow money from the abroad, but the state government are not allowed. The borrowing by states from the union government or the other state government. Property suits, this is not important. Right to property I have already discussed. Next part 13, trade, commerce and intercourse within the territory of India. Article 301, freedom of trade, commerce and intercourse within the states. No state can arbitrarily restrict the trade commerce. 302, power of parliament and power of states. 307, a commission authority may be appointed by the president. Next, services under the union and state. So now you should know Article 312, all India services and there are only 3 All India services: IAS, IPS and Indian Forest Service. And different provisions about the All India services. Okay, Article 315, Public Service Commission. Article 315 include the Public Service Commission, the Union Public Service Commission UPSC, State Public Service Commission SPSC, Joint Public Service Commission JPSC. UPSC has one chairman, 10 member, or are appointed by the president for the 6 year or 65 years, and they can be dismissed by the president after the reports of Supreme Court judges. Different type of provisions about the commissions. Expenses, finances, okay, tribunals, and this was added by the Indira Gandhi government in 1976 by the 42nd Amendment. Administrative tribunal like the CAT, Central Administrative Tribunals, and other tribunals for the other matters. This is the next part, and the next part, election. Article 324 makes provision about the Election Commission of India. And Election Commission of India conduct election of Lok Sabha, Vidhan Sabha, Indian President, Vice President, and the commission has one Chief Election Commissioner, other commissioners. Now the 3-member commission, all are appointed by the President for the 6 year or at the age of 65. Article 325 makes provision for the electoral rolls. Article 326 provides the adult franchise to all person, and this is not a constitutional right, it is a legal rights. Okay, power and functions of commissions. Next, special provisions relating to the certain classes. Article 330, reservation for SC/ST in the House of People. Lok Sabha has given the reservation to SC/ST. Okay, 331, Anglo-Indian community in House of People. Now it has been seized. 332, representation of SC/ST in the state assemblies. 333 now have been seized. 334, reservation of can be extended, right? Next, Article 338, National Commission for Scheduled Caste, and Article 338, National Commission for Scheduled Tribes. Initially they were the joint commission, but now they have separated. Article 340, the commission investigation of OBC. The term OBC has not been defined in this article. Article 341 mention the scheduled caste but not defined. 342 mention the scheduled tribes but not defined. Okay. Next, the official language. Article 343, official language of the union is Hindi and English is subsidiary language. Okay. And 14th September is celebrated as the Hindi Day. And Article 344 makes provision about the official language commission. 345, official language. Now there are 22 official language in 8th schedule. Then official language of communication between central and state. 347, population. High Court and Supreme Courts are entitled to use the English language in their proceeding. 349, 350, language to be used in representative of 350A, 350B. This is not 130B, this is the 350B. And these are added by the 7th Amendment in 1956. Okay. 351, directives for development of the Hindi language. How can we promote the Hindi language in a different purpose? Next, the emergency provisions, proclamation of emergency. 3 kinds of emergency has been proclaimed under the Indian Constitution. Article 350, the national emergency. 353, effect of proclamation of emergency. Article 352, President is authorized to declare the national emergency on the advice of Union government. Only 3 times it has been declared. 1962 during the Indo-China War, 1967 Indo-Pakistan War, and 1975 on the internal disturbances by the Indira Gandhi government. Okay, and these are the effect of emergencies, the conceptual part. Article 356, The failure of constitutional machinery in a state. This is also called the president rule in the state. The state government, chief minister, other minister can be dismissed if they are not working according to the constitution. The president can dismiss the state government. This is called the president rule in a state, and it has been applied more than 100 times. And Article 360, the provision of financial emergency, and it has not been implemented yet.